SwayamPrabha. Digital India. Educated India.
Good morning viewers, I am Dr. Ashwini Siwal from Faculty of Law, University of Delhi. I am here to discuss a very important area of law, that is AI and Indian legal judgments. And this particular topic of AI and Indian legal judgments is in the series called Law, Science and Technology, wherein we are learning the interfaces of law, science and technologies, even disruptive technologies as well as exponential technologies we are incorporating here. So my dear viewers, let us be fascinated and be ready to get fascinated with lot of important developments in the field of AI, especially in the context of Indian legal judgments. You all are aware that our courts are overburdened with the cases which are pending in the courts in India, be it a Supreme Court or the High Court or the subservient judiciary. They are overwhelmed and overburdened with the cases. But now the good news is that we have artificial intelligence enabled tools to help the courts in the easier and speedier disposal of the cases. But does it really work so easily and so efficiently as it sounds? This is the question before us, which we are going to discuss today in great detail. Viewers, you might have heard that lot of automated tools enabled with artificial intelligence are used in the judicial systems across the globe. But is India ready, or are judiciary ready for this kind of mechanism or these new technologically laden tools? These are some of the perplexing questions and very inquisitive questions which I have for you to get answers and for you to deliberate. So to begin with, I would first tell you what is artificial intelligence, how it works and what are its advantages as well as what are its disadvantages. There are a lot of advantages, but it does not only come with advantages, it comes with several disadvantages. And in the context of judicial system, especially in judgment writing, judgment curation or judgment annotation, there are a lot of difficulties which, as a law scholar of this particular area of law and AI, I myself have witnessed. In fact, in one of our projects recently concluded with Institute of Eminence at University of Delhi, we found that the application of AI is not so easy as it sounds on Indian legal judgments, because there are inherent challenges in the Indian legal judgments. The judgments which are written by different judges have no uniform format, they have no uniform pattern. The judgments are written or authored by judges in several ways or in varied ways, which is why it is very complicated to apply the AI tools or automated tools for getting the analysis of the judgment so easily. So let us learn these things one by one in this today's lecture. And here we come. Well, if we talk about the introduction of it, well, this era of machines and reliance on machines, even for the smallest of the tasks, is a natural phenomenon. We have seen that civilizations developed and evolved by the usage of different technological developments and tools. So is the case with the artificial intelligence or use of the automation. Artificial intelligence is one such remarkable solution in the field of legal industry, but this is arguable whether it is really remarkable and whether it is really efficient or not. Now moving ahead, in common parlance, what does artificial intelligence mean? This can be described in contrast to natural intelligence by humans. It is a machinery or a robotic system of providing quick and prompt solutions. It is rapidly advancing in the field of computer science. We all know that there are a lot of advances which the world is witnessing in the field of AI, and it has become a buzzword like industrial revolution in the past, or for that matter information technological development in the past, but this is a new buzzword or talk of the town these days. In the mid 1950s, John McCarthy, who has been credited as the father of AI, defined the AI as the science and engineering of making intelligent machines. This is how John McCarthy described it, that it is a science and engineering or blend of both making intelligent machines. Conceptually, AI is the ability of a machine to perceive and respond to its environment independently and perform tasks that would typically require human intelligence and decision making processes, but without direct human intervention. Well, this is really a big statement, whether AI really requires direct human intervention or not. Generating basic algorithms or generating basic structure requires human intervention, but now we are hearing that, or we are witnessing the age where AI is generative or it creates the knowledge on its own, which is why I am saying that this statement is noticeable here and needs to be re-investigated, because now it may not require the human intervention, and in some creations it has been seen that AI does not require any human intervention, which is a challenge in case of legal issues or pertaining to law, because it leads to ownership issues, it leads to sometimes title issues. We will discuss those things. Going further into the details of the or underpinnings of the definitional contours of artificial intelligence, it is the ability of a digital computer or computer controlled robot to perform tasks commonly associated with intelligent beings. The term is frequently applied to the project of developing systems endowed with intellectual processes characteristic of humans, such as the ability to reason, discover, generalize or learn from past experience. So, now we are getting new definitions of AI which are more wider in their sweep and more encompassing in their nature, and they are not just restrictive to ability to reason, they are rather expanding to discover meaning or expanding to other ways in which AI may react or other probable outcomes or outputs of the AI. Artificial intelligence as the theory and development of computer systems able to perform tasks normally requiring human intelligence, such as visual perception, speech recognition, decision making and translation between languages. Right? These are some of the definitions which we have. It is an area of computer science that deals with giving machines the ability to seem like they have human intelligence. It is a type of computer technology which is concerned with making machines carry out work in an intelligent way, similar to the way a human would react. Well, these definitions are summarizing or indicative that machines, or you may say that automated tools these days have their own intelligence. They do not require or may require very preliminary human intervention, and the intelligence is not just restricted to ability to reason, it has many or multi dimensions. For example, it has a decision making, it has a speech recognition, it has several other manifestations, or it is evolving constantly. Moving ahead, in short, we may conclude that it is the ability of a machine to think, act like humans or replicate cognitive functions that humans associate with other human minds, such as learning and problem solving. So, by these definitions, or after having looked at these definitions, it is clear that AI is no more just basic automation or automated tool. It is rather having capacities which a human mind may possess or possesses, like decision making, problem solving and thinking or acting like humans. Even emotions at times have been seen in the AI enabled devices or AI enabled robots. Well, the European Commission, so far as the legal developments in this context are concerned, viewers, the latest development in the field of AI and law is in the European Union, wherein the EC has proposed a legislation to regulate AI, usually called the Artificial Intelligence Act. They have brought a Artificial Intelligence Act. This is the first of its kind, or you may say this is the pioneer nation who has brought or which has brought the law on artificial intelligence or act on artificial intelligence. So far, there have been lot of other developments in other jurisdictions in the form of rules, regulations, binorms, but law has been enacted by the European Union for the first time to regulate artificial intelligence, which is called Artificial Intelligence Act, and it is an of late development. In this act, the definition of AI reads as, in this act the definition of AI reads that artificial intelligence means software that is developed with one or more of the techniques and approaches listed in Annex 1 and can, for a given set of human defined objectives, generate outputs such as content, predictions, recommendations or decision influencing the environment they interact with. This is a very all encompassing or a broad definition provided therein in the Artificial Intelligence Act, which will become a kind of benchmark for other jurisdictions to follow and replicate. So, this definition will become or will gonna become the benchmark in other jurisdictions, wherein the jurisdictions may replicate it or may repurpose and reuse it. Now, if you look at the Annexure 1, we see that artificial intelligence techniques and approaches which are mentioned in the definition have been stipulated here. What are those? These techniques include machine learning, including supervised, unsupervised learning. It includes logic and knowledge based approaches. It includes statistical approaches, right. So, this is the way in which the European Union has defined the artificial intelligence, that anything or any particular technique and approach, machine learning approach, logic based or statistical approaches are basically artificial intelligence or are basically the basis of the artificial intelligence for a given set of human defined objectives, and they generate output such as content or predictions or decision making. Well, what are the challenges faced by legal practitioners? Now, coming to this aspect, which is very important aspect. Well, my dear viewers, since our lecture is revolving on what? Law and Indian legal judgments, or you may say artificial intelligence and its application in the Indian legal context or Indian legal judgments. So, for that we need to understand the challenges faced by the legal practitioners across the globe. The legal practitioners has to go through vast amount of data to find relevant information. They have to read very lengthy judgments, statutes, they have to read laws, bylaws, they have to read precedents and lot of other text, which is a cumbersome thing, So, not so very easy for a particular legal practitioner to read vast amount of information and data, and the kind of hurry in which the client of a particular practitioner is found or is in leads to what? Either inefficient services rendered by the legal practitioner to him, or it leads to just hushing up the matter rapidly with no efficiency, right. But we have an answer in the form of AI. AI can help here by bringing some solutions to it, which we will discuss. Then there is another challenge for the legal practitioners that in drafting there may occur a human error. Humans are not machines. Machines may be impeccable, but humans cannot be impeccable. There lies always a flaw in the human decision making or human drafting, which is why AI, or which is where the AI may come and help. It is a help which may reduce the risk of human error. Then case study is time consuming. We all know that I just mentioned that they have to read lot of judgments, so it is time consuming process. We know that it is cost inefficient because lot of platforms are there which the legal practitioners have to subscribe to, like AIR, SCC and so on and so forth, right, and it results into what? Lot of cost. They have to spend lot of money, yet they cannot produce good output, and inefficient they remain as they were earlier, despite or irrespective of subscribing to these lot of platforms. Now it leads to what? Ultimately it leads to delay, because we have heard in the courts a very popular phrase, tarikh pe tarikh and date pe date, which is why it leads into delay in legal judgments, because the entire work is manual by the legal practitioners. But we have an answer to this problem, that is AI. As per the records of 2022, over 4.7 crore cases are pending. How many? 7.4 crores cases are pending, which is an alarming and very humongous number, right, in courts across different levels of the judiciary. Of them, 87.4 are pending in subordinate courts and 12.4 in high courts. Well, these subordinate courts are the most inefficient and they are overburdened, unlike even high courts or the Supreme Court for that matter. They are overburdened. They are actually just not dispensing the justice, they are rather disposing the cases. So to address this issue, we need what? We need some efficient mechanisms, efficient tools, and we have such tools. In this age we have artificial intelligence, but will the application of artificial intelligence in the context of Indian legal practice help or not? This is one such question which we are going to discuss in great detail today, with the shortcomings and with the challenges over there. Moving ahead, what are the positive implications of using AI? Well, as I told you, there are a lot of positive things about using the AI. There are of course challenges, but it may improve in access to justice, because justice may not be delayed, right, and delayed justice is a denied justice, right. There is no point of dispensing the justice if it is delayed. So we will have improvement in the access to justice. AI can help cut down on the amount of cases that are waiting in Indian courts. Judges and solicitors can more easily analyze, evaluate and interpret data, and thanks to these technological ability to quickly locate critical information from vast quantities of legal documents. As a consequence, disputes may be settled more rapidly, cutting down on the amount of time needed to resolve cases, which can save the court money and lower the expense of litigation for the public. But are these benefits really pragmatic, or are these just rhetorical ideas or statements? Let us have such discussion in the ensuing slides, but these are some of the positive implications or probable positive implications, right, probable positive implications of using AI. Then making decisions more efficiently. The courts may decide things more efficiently, because as I told you that human error may lie, even biases may come, but machines may have no biases. Machines may have no error in decision making, and that is how the machines may be more efficient vis-a-vis to the humans. AI can look at a lot of data and analyze trends that human specialists occasionally overlook. judges and solicitors can provide more accurate outcomes by making clear and informed decision. But again, this is a statement which needs further evaluation, because the biases may occur even in the AI enabled machines or AI enabled judgment writing tools. We have witnessed that some racial discrimination, some discrimination on the basis of some peculiar identities like caste, creed, sex, or for that matter religion may occur or tend to occur even in the machines, and it has already occurred in several jurisdictions. It has already been noted or reported. Moving ahead, efficiency will ultimately quickly analyze the voluminous data and save time of the legal practitioners. As a result, everyone may have better access to the court system and the legal system may function more effectively, right, and it saves the litigation cost, right. As a result, both litigants and the court system may significant cost saving, and this particular money may be used or utilized for the purposes of development of the other infrastructure. The money will not go waste in long pending procedures before the courts of law, which are very technical, which are languishing, which are delayed, which are not efficient. What are the challenges of using AI? Now coming to this aspect, as I told you that bias is one. Artificial intelligence system may reinforce prejudicial attitudes already present in the legal system, producing biased outcomes. This is especially true in India, where the legal system is alleged to treat marginalized communities unfairly, right. It is already alleged to treat marginalized communities unfairly. Analyzing the training data and techniques employed by AI system in detail is crucial to lowering this risk of bias. So, whosoever is training or the legal researchers as well as the technical researchers or researchers from the language processing, right, NPL, they have to be careful that they need to avoid the risk of the biases. Which biases? The biases which may occur because of the prejudicial attitudes, right, and it may be avoided by training the machines or the tools by not employing the prejudicial attitudes in the machines or in the particular tools, right. This is very important. Then lack of transparency is another challenge. AI systems are frequently secretive, making it challenging to comprehend how judgments are made. The judicial system may become less trusted as a result of this lack of openness or lack of transparency. Well, this is again true that most of these tools will be working on some algorithms, some program interfaces, some such source codes which are beyond the comprehension of humans, which are beyond the comprehension of commoners. So, in that case there may occur a lack of openness, and which leads to what? Lack of trust amongst the justice seekers, right. It needs to be taken care of. Then we have limited data availability. Well, this is the most important challenge, because we ourselves has faced it while curating the Indian legal judgments in a project. We were curating the Indian legal judgments and we found that the availability of data, uniform data is a problem, right. And for AI system to function properly, they need a lot of data. The machine needs to be fed with lot of data, and that data has to be uniform. It is difficult to adopt AI powered systems successfully in India, since there is a dearth of digital data in the judicial system in India. We recently started digitizing our Indian legal judgments or recently started digitizing Indian legal judgments propounded by the courts in India or other procedural matters in the courts in India, which is why there is a dearth of data, and when there will be limited data, the machines may not be fed with adequate data to decide adequately or appropriately. Then there are ethical issues which I would like to quickly touch upon. What are those ethical issues? The employment of artificial intelligence in civil disputes poses ethical issues related to privacy, autonomy and accountability. Privacy, autonomy and accountability in the civil disputes. To guarantee that AI is utilized in a responsible and ethical manner, careful examination of these issues is required. What kind of privacy or issues pertaining to autonomy and accountability may occur in the civil disputes? Let me tell you that civil disputes may pertain to a problem amongst the spouses, say a dispute pertaining to a spouse alleging impotency in a husband. When such thing is disclosed to a court of law or when it is argued in the court of law, here the privacy issue may arise. What the court system follows in India or in the rest of the world, that they conceal or they hide the identity of such petitioners, or for that matter anybody who is suffering from some sexually transmitted disease, and his marriage prospects may get diminished or diluted if a machine discloses that this person is having some sexually transmitted disease, be it AIDS or for that matter herpes or for that matter any other sexually transmitted disease. So, such are the privacy issues and autonomy issues which may occur in the civil disputes in the courts of law because of the use of the AI tools. And then a very far fetched, not so logical, job losses. I will not agree, but this is also very common and very prominent argument given by the legal practitioners, that they may gonna lose the jobs as a result of use of the AI in civil trials, or they will get replaced by the tools and their profession may see a dearth of employment. But I think that this is not true, because nothing so far, no technological revolution has reduced the use of labor, except by providing the efficient ways of using the labor. It has not diminished the use of the labor, or replacing the cognitive capacity is altogether a very difficult task, or altogether a different ball game. So, I do not believe that cognitive capacity of a person may get replaced so easily, right, because at the end of the day it is the human intervention which is required even for creating a basic artificial intelligence tools. Now, look at the statistics. If we look at the statistics, we see that the judiciary has this trend of disposal of the cases, and we see that there is a very poor disposal. The red line here shows the poor disposal graph of the judgments. On the other hand, wherever the AI tools are used or some institutional mechanisms laden with AI is used, we see the efficiency, right, and the disposal increases, right. AI systems used in the legal field around the world. If we look at this, then we find that there are a lot of AI systems which are used in the legal field around the world. And what are those? Let us have a look at all these one by one, and then we will come to what may be the best for India to use, or which particular model will be best for India to use. Well, this is one particular system that is called Roche Intelligence, developed in 2014 at the University of Toronto, and most advanced technology of natural language understanding as of yet, or as on date. This is a very important tool, or you may say the most advanced tool of the natural language understanding used in the legal field in University of Toronto or developed in the University of Toronto allows you to ask your legal issues or describe the facts and procedures to the system in natural language instead of using Boolean terms or keywords. Well, nowadays we all use such tools or devices which recognizes our speech and which function very well on the basis of the commands given by our speech. But back in 2014, this was a new thing, and in the legal field for the first time this intelligence was applied, and it was found that if you describe the facts and procedures to the particular machine instead of using the Boolean terms or keywords, it gives you results, right? It gives you results. Then we have Kaira systems, which especially was designed for recognizing, extracting and examining clauses from contracts and various other legal documents. Well, this is more advanced vis-a-vis to the earlier one, because it not only just help you to ask your problem, legal problem on the basis of the facts and procedure, rather it also recognizes, extracts and examines clauses from the contracts and various other legal documents, which makes your work faster and simpler and efficient. It saves 20 to 60% time for the first time users and saves around 90% time for the experienced ones who know how to employ this tool, and it reviews the contracts with 100% accuracy, automatically highlighting and extracting the related text within seconds. Well, now look at the tremendous results, very positive, very encouraging results which Kaira system brings in the legal field, right? Then it was designed to review contracts in different languages such as Spanish, French, German, etc., and can learn new languages too. So again, it has an important feature that it is not restricted to one particular language, say English or say German, rather new languages may also be employed there. Moving ahead with the eBrevia, developed in 2012 by 2 Harvard Law School graduates, and it was used to find out relevant text from various long and complicated legal documents and contracts within a very short period. This uses AI and advanced machine learning to identify and extract content from a contract and makes a summary report of that extracted part. Well, look at the entrepreneurship or legal, I will call it a legal entrepreneurship, right, of the law graduates at Harvard Law School in 2012, who found what? The machine or AI enabled tool to find out relevant text from long and complicated legal documents and contracts. We all know in the legal profession that the judges or the judgments delivered by the courts of law are very long, or at times they spread in thousands of pages, right? Forget about the words, thousands of pages. To mention few judgments, even the judgment on privacy on privacy delivered by the Supreme Court spread into some 800 plus pages. The judgment on Ayodhya Ram Mandir dispute spreads in some 1700 pages. So we know it is very complicated for a legal practitioner to read and conceive, as well as to learn or to assess or extract important parts like ratio decidendi, obiter, etc., from such lengthy judgments. So these tools which use AI and advanced machine learning, they identify and extract content from a lengthy judgment, and they quickly make a summary report of that extracted part, which is the beauty of it. Something may be explained so very quickly to the judge from the extracted part, and even a summary may be produced to the court of law. And we all know that judgments, Indian judgments are basically what? They are public works. Under the copyright law, it is clearly mentioned that judgments are public works. They do not have any copyright of one individual or of the court for that matter. Anybody may use the judgment. So copying or reproducing, or you may say even summarizing those judgments or abridging those judgments through machine tools may not land you into copyright issues, or for that matter intellectual property issues, right. Now moving ahead, it saves 50% to 60% of time. eBrevia can extract important information from a contract, customize that extracted data and present it in Word, Excel or other databases. Look at the beauty, you may keep it in Word, Excel or other databases very easily with the click of a button. Load Geeks is another such tool in the legal field, developed in 2014 by Nouri Bichor and Elan Edman, and it was developed for reviewing the contracts, and it is an automation solution that has been designed to manage, review and approve daily contracts and business agreements through AI, right. Now moving it resulted in the reduction of human errors, as the AI based system automatically detects and highlights the questionable clauses within seconds. It also reduces the risk of errors, right. Then this helps the company's legal team to concentrate and work on more important legal matters. And what is more important? Well, it is important that more time in the court is spent on arguments. It is important that more time is spent on dispensation of the justice to the needy, instead of wasting time on reading, summarizing lengthy judgments by the practitioners of law. Moving ahead, we have another tool in the legal field, that is FEXIATO, developed by a Chinese company named Wusong Network Technology in 2016, mainly to analyze a case and to recognize the type of case, and provides the best possible ways to solve the dispute. Well, it is to analyze the case, recognize the type of the case and provide the best possible ways to solve the dispute. It has employed a one step ahead of what we have seen in the earlier tools, that it also provides a best possible way to solve the dispute or give you some hypothesis for solving the dispute, help people to choose the best attorneys that are ideal for representing them in court. But this may be prejudicial, right, but again it is important for those who are ready to risk such prejudice, and they can afford to have only those practitioners employed or commissioned by them who appear into such search, right. Then XEFA is another tool introduced in the course of Beijing to provide legal services to judges, litigants and court officials, and it is 1.46 meters in height and explains the legal matters in a child voice. Well, it is a kind of a robot, you may say, a robot which is delivering justice, and it explains the legal matters in a child's voice to the courts or to the officials of the courts as well as to the judges in Beijing. Manufactured to explain complicated legal matters and legal definitions to people in a very simple language, and helps in reducing the cost of litigation, improves the efficiency of the justice system and saves the trial resources, right. Trial resources, this is what I was mentioning, that more time should be saved for trial, for argument to take place in the court, for rationality to or some logic to be applied by the courts, instead of wasting time in the paperwork or in the summarization. Well, now see what are the applications of the computer technology in legal field in India. We have seen developments in the legal field in other jurisdictions, right, in Beijing, in Toronto and in many other jurisdictions, but now what is happening in India, where have we reached or where are we standing right now in terms of the development. Well, our courts have some e-courts projects, or you may say Indian judiciary have e-courts project, which basically was conceptualized on the basis of National Policy and Action Plan for implementation of information and communication technology in the Indian judiciary in 2005, and it was submitted by E Committee of the Supreme Court of India. Well, this is interesting that our country or our judicial system recognized the read in year 2005, very long, 2005, now it is 2024, and it's been good around 20 plus years when our courts have conceptualized this particular idea, and they have tried to implement ICT in the Indian judiciary, and this was basically backed by the Supreme Court of India or its E Committee, right. It is a pan India project monitored and funded by Department of Justice, Ministry of Law and Justice, Government of India. It has been implemented in phases, and or you may say it was implemented in the phases. Phase 1 and phase 2 had dealt with digitization of the judiciary. I told you that there is a dearth of data or digitized work in the case of judiciary. Digital judiciary or digitizing the judiciary is one such step which was covered in the phase 1, like e-filing, e-tracking, uploading judgments online, etc., or making them digitized. Then in phase 3, the plan was to upgrade the electronic infrastructure of the judiciary, and we all witnessed in the recent past during the COVID period that our courts were operational very efficiently and fully, even without the physical presence of the lawyers, of the judges and of the litigants in the courts of law. They were working very efficiently through the infrastructure which was developed over the period of time in phase 3 of the e-courts project. The e-court project was conceptualized with a vision to transform the Indian judiciary by ICT enablement of courts. The E Committee of the Supreme Court of India recently released its draft vision document for e-court project, right. They have recently released the draft vision document, and the Supreme Court has directed all the courts to extensively use video conferencing of judicial proceedings in the wake of the pandemic, right, which we just discussed. In May 2020, the Supreme Court introduced a new system of e-filing and artificial intelligence enabled referencing. Well, we saw a good and noticeable development in 2020, where Supreme Court introduced e-filing and artificial intelligence enabled referencing. AI enabled e-filing, AI enabled referencing was introduced in 2020. Further, the use of AI technology in legal field in India may be further understood and seen by AI portal for Supreme Court, which is called SuPACE, and it stands for Supreme Court Portal for Assistance in Courts Efficiency. SuPACE stands for Supreme Court Portal for Assistance in Courts Efficiency. It was launched to enhance the productivity of the legal researchers and judges in India. SuPACE is AI enabled assistive tool that can augment the efficiency of the legal researchers and judges to work on cases, extract relevant information, read case files, manage teamwork and draft case documents. But the problem is, how many lawyers are using it? How many law practitioners are even aware about it? And how many are trained to use this facility provided by our own Supreme Court, that is Supreme Court Portal for Assistance in Courts Efficiency, that is SuPACE, which is a AI enabled assistive tool. Then we have AI system to read legal judgments. IIT Kharagpur or the team of researchers at IIT Kharagpur have developed an artificial intelligence aided method to read legal judgments, which can not only tell which laws are getting violated, but also in the process help minimize legal costs. This can give legal guidance to the common man to ascertain if there is merit in taking a particular situation to court, which reduce at the base, at the bottom the litigation, because if the litigant is told free of cost that his argument or his matter may not sustain in the court of law and it has no merit, it has no standing, then he will not proceed with the litigation in the court, and which at the bottom or at the very first instance reduces the chance of proliferation of the cases in the court of law. So, this is very important tool developed by the IIT Kharagpur team. Then we have Supreme Court judgments available in vernacular language. We have a tool called Vidhik Anuvad, a software called Suvas of the Supreme Court. Supreme Court Vidhik Anuvad software, a machine learning tool being used for translating Supreme Court judgments into vernacular languages, and the apex court has started translating daily orders and rulings into 9 Indian languages, right, such as Assamese, Bengali, Hindi, Kannada, Marathi, Odia, Tamil, Telugu and Urdu. This initiative focuses on enabling better access to justice for litigants by providing them with access to knowledge. Well, this is a very important step by the Supreme Court of the country, because in our country, which is very diverse, lot of languages are spoken here, and there are lot of dialects in which people speak and communicate. So, the apex court started translating daily orders and rulings by employing this Vidhik Anuvad software, and it is now translating the judgments which are ordinarily pronounced or written or authored in English into 9 Indian languages, which makes it very comfortable and very easy for the locals or for the commoners to read the particular judgment in a particular language like Hindi, Kannada, Marathi, Odia, Tamil, Telugu, Urdu, right. And it will expand with time. They will probably increase or bring in new languages or translate the judgments into new languages. Then coming to summarization of legal case documents. In India, automatic summarization of legal case documents is an important and practical challenge. Apart from many domain independent text summarization algorithms that can be used for this purpose, several algorithms have been developed specifically for summarizing legal documents. However, most of the existing algorithms do not systematically incorporate domain knowledge that specifies what information should ideally be present in a legal case document summary. Well, of course, this automatic summarization of legal documents is very important, but it has certain practical challenges. So, what are those challenges? They are domain independent, many algorithms which are in use or can be used for this purpose or have been developed specifically for summarizing legal documents. They are somehow restricted. However, most of the existing algorithms do not systematically incorporate domain knowledge that specifies what information should ideally be present in a legal case document summary. Like when we talk about the domain, like judgments pertaining to IPR, taxation, or summarization of say antitrust, or civil, criminal, and so on and so forth. So, this domain independence of text summarization is needed, right, but the existing tools are domain dependent or domain specific. If you have one particular tool which restricts itself to IPR, then it will answer only queries pertaining to IPR, it will not answer queries pertaining to taxation, right. Automated extraction of catchphrases from legal documents. Legal documents can be lengthy and convoluted, making the task of understanding them strenuous and time consuming even by legal practitioners. Thus, there arises the need for a concise representation of the legal statement, which is captured through catchphrases from the legal documents. This has also been employed in India. Use cases of AI in legal field. Let us see where the legal where the AI in the legal field in India has been used. So, we see that legal documents analysis with the natural language processing, we see that to find inconsistencies legal text and contracts, extract useful data and check them against current law or rules, the AI may be used. For extraction of the document information, such as publication date, location, author. The AI may be used, or tools of AI may be used. For legal research, finding information relevant to legal decision, AI tools may be used. For electronic discovery, determining the relevance of document to an information request, the AI tools may be used. For contract review, for document automation, right, and for legal advice, for predicting outcomes, for generating automatic pleadings, for document review and contract analysis, for classification and grouping of documents, for studying and examining and making summaries of the documents, for performing different administrative functions and granting bail, parole, probation, and for settlement of cases based on predictive analysis. AI tools can be employed or may be employed. So, AI has developed to this extent, where in all these cases as highlighted, for legal advice, for settlement, for granting bail, parole, for classification, for document review, AI tools may be applied. Let us have a look at some case laws quickly, which are definitely handy for you to look and understand the application of AI. The case of Christine Louboutin versus another versus the shoe boutique, Delhi High Court asserted that in its present state of technological development, AI cannot replace human intelligence, right? It cannot replace human intelligence in the adjudication process. It emphasized that responses from AI chatbots cannot serve as the basis to adjudicate legal or factual matters in a court of law. So, the law making agencies like courts in India are not giving very encouraging observations. These observations are not very encouraging because the courts, or especially Delhi High Court in this case, has emphasized that responses from AI chatbots cannot serve as the basis to adjudicate legal or factual matters in a court of law. But I think the judiciary in India, given the pendency, given the shortcomings in the dispensation, in the justice dispensation system, must relook at it or their observation, and must be on a trial basis exercise these tools and then finally conclude. I think that it is required. Then Delhi High Court concluded in this case that chat GPT cannot serve as the basis for adjudicating legal or factual matters in a court of law. This is because firstly, the response from the large language model based chatbots like chat GPT depends on various factors, including the nature and structure of the user's query, training data, etc. And secondly, there are possibilities of AI chatbots generating incorrect responses, fictional case laws, imaginative data, making the accuracy and reliability of AI generated data a grey area. Well, I agree or second the observation of the Delhi High Court that such tools based on large language models, they suffer from lot of inherent shortcomings, and there is definitely a possibility of resulting into incorrect response and hypothesizing fictional cases or imaginative data. But over the period of time, by feeding adequate and efficient data, which is a prerequisite for any AI tool to operate efficiently, this may be overcome, or this problem may be overcome. I am quite hopeful about it. The High Court of Punjab and Haryana recently employed chat GPT in a case to determine bail jurisprudence in Jaswinder Singh versus State of Punjab, right. So, it is very encouraging. One court is saying that it may lead to incorrect responses, another court is employing it at the same time, right, in the same country. Then in this case of Jaswinder Singh versus State of Punjab, the court asked the following questions to Chat GPT. What is the jurisprudence on bail when the assailants assaulted with cruelty? In its order, the court specifically mentioned that any reference to Chat GPT and any observation made herein above is neither an expression of opinion on the merits of the case, nor shall the trial court advert to these comments. This reference is only intended to present a broader picture on bail jurisprudence where cruelty is a factor, right? And this is very encouraging. The court has clarified that it shall not be treated as a tool verified or vetted by the court or a very important agency, that is High Court of Punjab and Haryana in India, but they simultaneously mentioned that this puts or presents a broader picture on bail jurisprudence where cruelty is a factor. So, what is the requirement of responsible AI? Let us see. Niti Aayog in India has done an extensive study of various principles, and in its approach, they guide the approach towards adopting, developing and utilizing AI. Then it analyzed Constitution of India and various judgments of the Supreme Court on the aspect of constitutional morality and fundamental rights of the citizens. It also paid attention to various AI case studies in India and around the world to study instances of harm caused by AI. So, our country is exploring the possibilities of using it effectively, right. It also considered various international standards for AI which have been developed by several international bodies, right. Based on such study, identified 7 broad principles for responsible management of AI, which are important for us to see. These principles are safety and reliability. AI systems must ensure. Niti Aayog, after having studied it in detail, have propounded or have opined these 7 principles for the effective usage of the AI in the legal field. Safety and reliability, and it reads that AI system must ensure reliability regarding their intended functions and must have built-in safeguards to ensure the safety of stakeholders. Then equality, AI system must be built keeping in mind that similar people in similar circumstances are treated equally, and this is basically to avoid judicial bias. Then inclusivity and non-discrimination, AI system must be developed to be inclusive of all stakeholders and must not discriminate through bias between stakeholders on religion, race, caste, sex, descent, place of birth, residence, employment, etc. Right. Privacy and security, AI systems must ensure that the personal data of the data subjects or data principals, also it may be also called data principals. In the new act, the term is not data subject, it is data principal. It must be kept safe. The privacy and security or the data of the users must be kept safe and secure, such that only authorized persons must access personal data for specified and necessary purposes. Principle of transparency, the design and training of AI system is key for its functioning, and the system must be audited and be capable of external scrutiny to ensure that the deployment of the AI system is impartial, accountable and free from bias or inaccuracies. Principle of accountability, since there are various factors in the process of developing, deploying and operationalizing an AI system, and various actors are there. So, the accountability structures for any effects, harms or damages by AI system must be clearly set out in a publicly accessible and understandable manner. Lastly, protection and reinforcement of positive human values. This principle focuses on the possible deleterious effects of AI system through collection of personal data for profiling, the use of AI system in manners contrary to fundamental rights guaranteed by the Constitution of India. So, in conclusion, I will say that the legal sector in India is one of the largest and is highly under digitalized. So, given its very conventional and traditional approach, the field of law in India seems to be very skeptical to adopting new technologies in its workings. Other reasons for hostility towards incorporating technology such as AI include high cost, lack of proper systems and data, privacy and security issues and ambiguity in the law governing such technologies. And while the legal profession is not immediately threatened by the advent of AI, the legal sector still awaits a major technological overhaul to smoothen the system. Notably, the Supreme Court committee National Policy and Action Plan for implementation of ICT in the Indian judiciary was formulated in 2005. However, the progress has been slow due to resistance from the stakeholders. To sum up, AI is no more a futuristic idea, but a reality. The world is on the point of transition to alter dramatically many sectors through AI and machine learning. AI is also assisting lawyers and judges by reducing the time taken to perform various tasks at numerous stages, and it is becoming undeniable that by saving time and trial time, decision making process, the courts of law would lessen and pendency would decrease. This ensures efficacious justice to the masses and will enhance the way we think or perceive things and change the outlook by exploring new horizons from space to oceans. It will bring a revolution in mankind and can become the most powerful and dominant human innovation in the history. Thank you very much, viewers, for listening me patiently. I will meet you again with a few more lectures in this series called Law, Science and Technology. Thank you very much.